Hi there, my name is Lauren Felice, and today I will be discussing Indigenous incarceration in Canada. In this video, I will begin by discussing a general overview of the overrepresentation of Indigenous peoples, including First Nations, Inuit, and Métis populations within the Canadian prison system. Throughout this presentation, I will be focusing on the Indigenous peoples in the Prairie provinces, which includes Saskatchewan, Manitoba, and Alberta, due to the fact that these three provinces hold the highest rates of Indigenous incarceration. Next, I will examine the legal context and what legal steps have been taken in an attempt to address this issue. Next, I will discuss the historical context, and finally, I will go over some of the current initiatives being done to address this overrepresentation. While admissions of white adults to Canadian prisons has been declining throughout the last decade, Indigenous incarceration rates have been surging. Currently, 36% of the women and 25% of the men sentenced to provincial and territorial custody in Canada are Indigenous, a group that makes up just 4% of the national population. Add in federal prisons, and Indigenous inmates make up 22.8% of the total incarcerated population. This trend also starts at a young age, with Indigenous offenders under 18 representing 53% of the prison population. Just to give a comparison so that these statistics really make an impact, the Indigenous incarceration rate is currently 10 times higher than the non-Indigenous population, which, to put in perspective, is even higher than the incarceration rate of the Black population in South Africa at the height of apartheid. According to a study done by the Office of the Correctional Investigator, Canada's harsh new mandatory minimum sentences imposed by the Harper Conservatives has increased punishment for a wide range of crimes, limiting parole opportunities and also broadening the grounds used to send young offenders to jail. In fact, Liberal public safety critic Francis Scarpellegia has blamed this failed crime agenda for the disproportionate number of Indigenous peoples in federal prisons. The Government of Canada has recently acknowledged that prisons are used as catch basins for social problems, with high concentrations of certain socially and economically marginalized racial groups, such as Indigenous peoples. In an attempt to address this issue, in 1996, Parliament reformed the Criminal Code to add Section 718.2e, which calls for sentencing judges to consider all available sanctions other than imprisonment, with particular attention to the circumstances of Indigenous offenders. However, due to the section's underuse, in 1999, the Supreme Court of Canada implemented the Gladue Principles, which require sentencing judges by law to acknowledge an Indigenous offender's history of dislocation, disadvantage, addiction, and abuse. Yet again, there has been widespread criticism of the principle's underuse, especially in the Prairie provinces, where it's most desperately needed. In addition, within the legal system, there is the issue of systemic discrimination. There's a dominant narrative in Canada to blame the disparities in incarceration on individual shortcomings. However, if we take a closer look at the Canadian justice system, discrimination is found at every stage in the process. These discriminatory practices work against an Indigenous offender from the moment a person is first identified by police, to their appearance before a judge, to their treatment in prison. One of the most common forms of discrimination by police is through carding. For example, as you can see on the graphic to the left, according to the data from the last 4 years from the Edmonton Police Service, Indigenous peoples are almost 4 times more likely to be stopped than white individuals. Due to this phenomenon, people are filming incidents of racial profiling and uploading them to Facebook to raise awareness for, quote, the crime of being Native, unquote. For example, Andre Bear, a 20-year-old student in Saskatoon, was randomly stopped by police with his 18-year-old friend. The image on the left captures the moment when Bear asked the police why they were being pulled over, and an officer tells him, "Shut up, passenger, we have a reason." Eventually, they were allowed to go with no reason given for the stop. In addition, this discrimination can represent a sort of symbolism for the state, leading Indigenous peoples not to trust the police or the state for safety. These actions can also leave a strong psychological impact. According to statistics from Maclean's 2016 study, when asked whether or not their racial group is viewed positively by police, Indigenous students were more likely to disagree or strongly disagree. On that note, these word clouds represent the results of the previously mentioned Maclean survey, where researchers asked post-secondary students in the Prairie provinces for 3 words that describe the police. In these diagrams, word size is proportional to the number of mentions. Therefore, for the non-Indigenous responses, we can see words such as authority, brave, safety, and strong. In comparison to the Indigenous responses, which feature words such as racist, scary, rude, aggressive, arrogant, stern, mean, and bullies. When it comes to their appearance before a judge, among Indigenous offenders, there are higher rates of sentencing, sentences are for longer terms, they are less likely to be granted parole, and are more likely to have parole revoked for minor problems. A part of this is due to the excessive use of the dangerous offender designation on Indigenous offenders. This section of the Criminal Code is intended to protect Canadians from the most dangerous, violent, and sexual predators in the country. But a growing number of Indigenous offenders are being jailed for life this way without substantial cause. Furthermore, unequal rates of being denied bail disadvantages Indigenous offenders. By doing so, they may have to wait months in an overcrowded jail awaiting trial, and this time in jail places them at risk of losing jobs, housing, and custody of their children. In addition, there can also be a misunderstanding of proceedings, as many Indigenous offenders have intellectual disability or fetal alcohol syndrome. Indigenous offenders are also discriminated against in prison. For example, they are placed in maximum security institutions at double the rate due to the fact that they are categorized as high-risk inmates, which are linked to conditions more common in Indigenous peoples, such as intergenerational trauma, alcoholism, abuse, poor education, and unemployment. Moreover, they are more likely to be placed in segregation and for longer. The Office of the Correctional Investigator found that the disproportionate number of Indigenous peoples in solitary confinement created barriers to access of rehabilitation programs. As a result, Indigenous peoples do not get paroled early, if at all. In addition, Indigenous inmates account for a large portion of both the self-harm incidents as well as suicide attempts in prisons, due to the discrimination within prisons, as well as the prison's inability to address the root causes behind the offender's crime. As the Canadian government has stated, a loss or lack of cultural roots and identity are the primary causes of involvement in the criminal justice system, and this loss of identity for Indigenous peoples can be traced back to historical causes. The legacy of residential schools specifically has caused intergenerational trauma, and as a result, self-destructive behavior can occur, low self-esteem, acting aggressively, and substance abuse. These aspects put Indigenous peoples at higher risk in the eyes of our legal system. In fact, 73% of Indigenous offenders in the prison system have a family history of residential schools, and 90% say that substance abuse was related to the offense. In addition, many are still dealing with the impact of being pushed into the child welfare system, which forced them to lose touch with their communities and their cultures. Half of the current Indigenous offenders in Canada have been in the child welfare system. In addition, the denial of self-government from the Canadian state has had a lasting impact. Ever since the Indian Act of 1876 dismantled traditional Indigenous systems of government and replaced them with British legal structures, Indigenous peoples have had a foreign body of law imposed on them. In terms of current initiatives that are being done, self-government treaties is one way in which Indigenous peoples can have control over their own legal affairs. The Truth and Reconciliation Commission stresses the importance of Indigenous law to reconciliation, and there has been progress on this front. To this day, Canada has signed 22 self-government agreements recognizing a wide range of Indigenous jurisdictions that involve 36 Indigenous communities across Canada. In addition, the development of First Nations courts have seen a lot of promise. For example, the Canoe-Quinton First Nations Court in northern Vancouver. This court provides a new way to handle the process of Indigenous offender pleading guilty. This process involves the victim of the crime, the offender, the families, friends, lawyers, and members of the community. The court also features elders, social workers, and counselors. After everyone involved has had a chance to speak, the judge will work with everyone to come up with a healing plan, which will focus on helping the offender, the community, and the victim of the crime to heal and move forward. The plan will help the offender to address the problems that got them into trouble with the law in the first place. For example, this may include mandatory drug or alcohol counseling. Each plan includes emotional, spiritual, physical, and mental components. This process offers an alternative which is designed to assist offenders to reintegrate into communities. To summarize, there's currently a drastic overrepresentation of Indigenous peoples in the Canadian prison system, which can be tied back to their history of colonization. Legal attempts to address the issue are often underused and therefore unsuccessful. In addition, there is systemic discrimination that targets Indigenous peoples at every stage of the legal process. Moving forward, there is a desperate need for the incorporation of Indigenous legal traditions as a key part of reconciliation. Thank you for listening.